All right, welcome to Week 14 Forum. This is Chapter 13 that we're dealing with this week, and that is the federal court systems. And that's an area that, again, a lot of people have difficulty understanding what it is that the federal court does. Obviously, they adjudicate the law, but in a lot of instances, we have too much television, too many television dramas, kind of obscuring what it is that what it is that the federal government does at any particular point in time. So this week, we want you to learn to identify the general types of cases and the types of courts in America's legal system. We want you to be able to describe the different levels of federal courts and the processes for appointing federal judges. We want you to be able to explain the Supreme Court's judicial review, the power of judicial review in national law, and describe the process by which cases are considered and decided by the Supreme Court. And then finally, we want you to describe the factors that influence federal court decisions. Um, the story at the beginning of the chapter is really revolving around a Supreme Court case, which is Janus versus the American Federation of State, County, and Municipal Employees, which is the AFSCM group. Mark Janus worked for the Illinois Department of Healthcare and served as a child support specialist. He chose not to join the union, um, largely, because I suspect he's a libertarian. And this is again the AFSCM is a huge union that represents 1.3 million public sector employees and retirees, including healthcare workers, corrections officers, sanitation workers, police officers, firefighters, and child care providers. So, despite not being an AFSCM member, Janus, because of previous court decisions, was nevertheless required to pay what are known as fair share fees to the union on the grounds that the union was providing a service to all workers in his sector of employment. In the form of what is known as collective bargaining. So non-members didn't get, they don't have to contribute to the AFSCM's political activities. The PAC organization, which did involve itself in political candidates, and we should not be too cynical about this. The AFSCM is closely aligned with Democrats. Janus sued the AFSCM, claiming that the activities of the public sector unions was inherently political, and he argued that the unions bargaining actually contributed to the state of Illinois' budget crisis. Uh, Janus's case went to the Supreme Court, where the death of Antonin Scalia basically left the court deadlocked, and so they held on to the case. Subsequently, of course, the Republican-controlled Senate at the time refused to hold confirmation hearings on Barack Obama's nominee. This happened, I believe, Scalia died in February of 2016, and they held on to the confirmation throughout the whole election year. And basically, the Republicans' argument was that the people should decide who would be the next person to nominate this selection. That it's too important. And of course, Garland, I think, had been nominated in March of that year, so it was even before the nomination campaign really got going. Um, and of course that enraged Democrats, and of course uh, Donald Trump won in 2016 and very swiftly moved to nominate and confirm Neil Gorsuch. And the Supreme Court subsequently handed down a 5-4 decision declaring that fair share dues constituted a violation of Mark Janus's First Amendment rights. In dissent, Elena Kagan criticized the majority opinion as an unjustifiable reversal of an established precedent and a serious erosion of public sector unions' collective bargaining power. Basically saying what the court has done is legalize free riding. The union provides a service in terms of negotiating for contracts, for getting better pay, better benefits, and things like that. But they aren't being compensated for that work. And so that was sort of, and basically, Kagan argued that this was a deliberate attempt to undermine the support, the financial support for public sector unions by what she described as weaponizing the First Amendment in a way that unleashes judges and now and in the future to intervene in economic and regulatory policy. Um, So, in an important sense, the story there is it matters very much who the judges are on these courts. Had the Senate confirmed Barack Obama's nominee, the fair share dues requirement would undoubtedly have been upheld. Then Senate Majority Leader Mitch McConnell's hardball tactics on Supreme Court nominees enraged Democrats and liberal court watchers. And of course, over the course of Donald Trump's one term, Republicans engineered the replacements of Scalia's position, and then they clearly twisted Anthony Kennedy's arm and got him to retire early, and replaced him with a much younger Brett Kavanaugh. And then, of course, Ruth Bader Ginsburg died literally in the midst, in the final days of the 2020 presidential election, and they rammed her, her confirmation through as well. So every year, approximately 25 million cases are tried in American courts. Judicial cases can range from relatively minor civil disputes between citizens to efforts by government agencies to punish wrongdoing. Some argue that the volume of legal disputes is evidence of Americans' inherent litigiousness. But given the alternative, which very often is violence, I think it's better for Americans to seek to resolve disputes through the courts. Um, the legal system basically exists to settle disputes. A court originally referred to the place where a monarch ruled. President or kings would be talking about holding court. That would be the place where they would sit and hear grievances and basically rule on these kinds of conflicts. Today, courts are comprised of venues where judges and lawyers settle disputes by an impartial trial of facts related to a dispute. The essence of rule of law is that the state and its officials are judged by the same laws as the citizenry. Okay, so there are basically two categories of American law: criminal law, which deals again with instances where the state is the aggrieved body. They decide what is a criminal act. Driving under the influence of drugs or alcohol. Killing another person, raping a person. These are all clearly articulated in the civil code. Okay, under criminal law, the state is always the plaintiff. Civil law handles disputes among individuals, groups, or corporations, and other private entities where there is no clear criminal activity alleged, but where nevertheless someone is thought to be harmed. The major kinds of civil cases involve contracts, torts, and administrative law. Contract laws, these are instances where people have entered into an agreement and one side or the other accuses that side of not upholding their terms of the bargain. An example would be, a corporation suing a distribution company for failing to honor a contract to deliver raw materials at a specified time, which would cause the former company to lose business. Torts involve charges where a person suffered injury due to another person's negligence or bad conduct. Medical malpractice suits are a good example of a tort claim. And administrative law involves conflict over the jurisdiction, procedures, or authority of administrative agencies. An example there might involve a complaint that an agency did not follow proper procedures when issuing new rules and requisites. So under the Administrative Procedures Act, a court might examine an agency's conduct to make sure that they are following the law. In American law, precedence is very important. And again, that means prior decisions from a court are very important in terms of deciding a case in front of a court. Precedents established in previous cases guide the court's decision in new cases. It doesn't always guide them. But the basic legal principle of what is known as stare decisis, which is called, Latin for let the decision stand. Courts are obliged to apply precedent or to identify a reason where prior precedent does not hold or should be reversed. And again, that's part of a state's commitment to rule of law. So again, I'm trying to just lay out sort of the basic groundwork for federal law. When we talk about it again, what is it when you say don't make a federal case out of it? What makes it a federal case? And more often than not, it's something where, for example, with bank robbery, it was a situation where people would rob banks and then flee across state lines, and that made it very difficult. That created jurisdictional problems that made it very difficult for for state and local officials to police those kinds of criminal activities. So let's have fun this week. I think there's a lot in here that's good fodder for discussion. I'm pretty sure that some of you are interested in the law at some level based on our prior conversations. So I really hope we'll have a really productive week.